Hey guys, welcome back to another new videos and LawGuru welcomes you. So today in this video we will be discussing section 41A of the CRPC, which deals with the provisions regarding the notice of appearance before police officer. In the last video we have discussed a case law, that is DK Basu versus State AIR 1997 SC 610, which gives the law relating to arrest. It is a Supreme Court case and Supreme Court has given some guidelines that should be mandatorily followed. Okay. Before starting this video, if you have not subscribed my channel, please go subscribe so that you all get CRPC related videos regularly. So let's start this video. What does section 41A says? Section 41A deals with the provisions of the notice for appearance before police officer. This section says the police officer shall, in all cases where the arrest of a person is not required, under the provisions of subsection 1 of section 41. We have discussed section 41 and its subsection 1 also. It says in what cases or when the police may arrest any person who has committed any offence without warrant. So in this case, the police officer shall, in all cases where the arrest of a person is not required, under the provisions of subsection 1 of section 41, issue a notice directing the person against whom a reasonable suspicion exists or a reasonable complaint has been made that he has committed a cognizable offence, to appear before him or at such other place as may be specified in the notice. So this section says the police officer shall, in all the cases where the arrest of a person is not required, under any of the cases mentioned under the provisions of subsection 1 of section 41. There are many cases in which the police may arrest without warrant, but in all the cases where the arrest of a person is not required, in any of the case where the arrest of a person is not required, then in that case the police officer shall issue a notice directing that particular person to appear before the police officer. This notice will include the offence that he has committed, or there is reasonable complaint that he has committed, or there exists a reasonable suspicion. Okay, this all will be specified in the notice, and the particular person has to appear before the police officer at such other place as may be specified in the notice. Okay. In simple language, the police officer shall, in all cases where the arrest of a person is not required under the section 41 subsection 1, the police officer shall issue a notice directing the person to appear before him or at any other place as may be specified in the notice. Okay. Where such a notice is issued to any person, it shall be the duty of that person to comply with the terms of the notice. If a notice is being issued to any person, then it shall be the duty of that particular person to whom the notice has been issued to comply the terms of the notice, to follow the terms or fulfill the terms of the notice, terms and conditions of the notice. Where such person complies and continue to comply with the notice, if any person to whom notice has been issued, if he complies and continuously follows the rules or terms and conditions of the notice, then he shall not be arrested in respect of the offence. In respect of the offence referred to in the notice, the notice shall contain the offence in which he has been involved, unless for reasons to be recorded the police officer is of the opinion that he ought to be arrested. Okay. But in any case, if such person at any time fails to comply with the terms and conditions of the notice, or fulfill the terms or follow the terms of the notice, or he is unwilling to identify himself, he is not identifying himself, then the police officer may arrest him. The police officer may subject to such orders as may have been passed by a competent court. In this behalf, arrest him for the offence mentioned in the notice. So in simple language, if the police officer has issued a notice under subsection 1, in simple language, if a police officer has issued a notice directing any person to appear before him at such and such place under section 41A, then that particular person has the duty to follow or comply with the terms of the notice. If he continues or complies with the terms of the notice, he will not be arrested unless for reasons to be recorded the police officer is of the opinion or has the opinion that he shall be arrested, then he shall be arrested. And in any case, if that person fails at any time to comply with the terms of the notice or is unwilling to identify himself, then police officer may arrest him. Okay, it is a form of notice that will be issued as per section 41A. This is a sample. Okay, in all the cases where the arrest of a person is not required under the provisions of subsection 1 of section 41, the police officer shall issue a notice directing the person to appear before him and to comply with the terms of the notice, the terms which are given in the notice. He shall follow. The person have to follow those terms and conditions of the notice. He or she can be arrested if such person fails to comply with such direction. Here, it is also said that section 41A of the CRPC, which was inserted by section 6 of the Criminal Procedure Code Amendment Act of 2008. Okay, and section 41A makes it clear that where the arrest of a person is not required under section 41A subsection 1 of the CRPC, the police officer is required to issue a notice directing the accused to appear before him at specified place and time. Law obliges such an accused to appear before the police officer, and it further mandates that if such accused complies with the terms of the notice or follows the terms of the notice, he shall not be arrested unless for reasons to be recorded the police officer is of the opinion that the arrest is necessary. Okay, there is a case law on this particular thing that I have said now. Rini Johar versus State of MP 2016 CR LJ 3156 SC. Okay, now can a magistrate issue notice under section 41A in course of investigation? Here the term is important, that course of investigation. So in the case of Ramesh Sopti versus State of West Bengal 2017 CRLJ 4163 CAL, the Calcutta High Court has held that the issuance of notice upon an accused under section 41A of the CRPC in the course of investigation during the investigation under section 202 of the CRPC by a police officer is illegal. Okay, I hope this video is informative to you. If you like this video, press the like button, share it, subscribe for more such videos, and if you have any doubt, please do comment. For then, stay safe. Thank you.